What? No. You can sit down, sir. Good morning, everybody. Hello, Miss Officer.
Good morning.
How are we today?
Oh, I'm sorry. Can you call me back in a minute?
Mr. Ryan, how are you today? Okay, Your Honor. Good.
Rising about Trident.
All right. Michelle, do we have a Zoom link up?
We do.
All right.
They're on, they're just muted and they don't have their video on. No, they don't need to do anything other than that. They're welcome to stay muted and with video on.
Okay, just want to make sure. Thank you. Yes.
Correct.
All right, Mickey, there are three cases here today for the court's consideration. They are 24 CR 112364, 21 CR 112365, and 25 CR 112922, State of Ohio versus Brandan Ryan. Mr. Ryan is in open court today with Attorney Kowalski, and Prosecutor Griffin is present on behalf of the state. There's also some representatives from one of the family members who are present participating today with Zoom. And Prosecutor Griffin, I understand prior to us discussing what may occur today, that you did reach out to the Marcy's Law individuals and victims in these cases to give them an opportunity to be heard or participate today. And in fact, as I just noted, one person decided that they wanted to participate by Zoom. Is that correct?
I believe it might be two people, but yes, at least one person is participating.
Okay. Mr. Griffin, you and you and Attorney Bobrowski have had a lot of opportunity to discuss Mr. Ryan's situation. For the record, we have jury trials scheduled for 5/20 in the first two matters, 24 cases. Where are we from your perspective, Mr. Griffin?
I believe that on all three of these cases, there's going to be a plea to each of those indictments. There will be no amendments on any of these cases, and we would ask the court to set this matter for a sentencing and order a pre-sentence report so that the complaining witnesses, the Marcy's Law individuals, can be present in court. We do have plea sheets on all of these things, Your Honor, and I've laid out with each case, first of all, the possible penalties. Obviously, there are possible driver's license suspensions for each of these, or all of these cases, and I've laid out the allied offense analysis on the plea sheets. I can go over that right now if you want, but I think I've done it accurately on all these plea sheets.
All right.
Go ahead.
Well, first question is, the OVIs on the second case, the middle case, there's two OVIs. Do you know what, and they're unclassified. Do you know what offense those OVIs are?
Yes. That is going to be, Your Honor, it's our understanding that that is going to be a third offense in 10 years. That's the way we indicted it. Now, the PSA might show something differently, but that's what we believe. Okay. That is, and I've listed the penalties for that offense on the plea sheets.
All right, and then why don't you, before I hear from Mr. Bobrowski and Mr. Ryan, why don't you tell me your merger analysis?
Regarding the case ending in 364, there's going to be, first of all, there is a forfeiture specification for $581 in cash and a Class 2 driver's license suspension for the failure to comply. Then I would submit that counts 1 and 4 are allied. The state would elect on count 1. Counts 2 and 3 are allied. The state would elect on count 2. Counts 5 and 6 are allied. The state would elect on count 5. Counts 7 and 8 are allied. The state would elect on count 7. So the defendant would ultimately be sentenced on counts 1, 2, 5, 7, and 9.
Gotcha. Okay, then how about 1, 2, 5, 7, and 9? All right, how about in the next case?
So on the case ending in 365, first of all, there are going to be driver's license suspensions for the counts, the aggravated vehicular homicide and vehicular assault counts, ranging from class 1 to class 4 suspensions. And again, I've outlined that on the plea sheets. Then we would submit that counts 1 and 3 are allied. The state would elect on count 1. Counts 2 and 4 are allied. We would elect on count 2. Counts 5 and 6 are allied.
A little quick.
Sorry.
So 1 and 2 are viable. 3 and 4 are allied.
Correct.
Okay, go ahead.
Counts 5 and 6 are allied. The state would elect on count 5. Counts 7 and 8 are allied. The state would elect on count 7. So the defendant will be sentenced on counts 1, 2, 5, 7, and 9.
1, 2, 5, 7, and 9. Okay,
Correct. Then on the last case, Your Honor, we would submit that the only allied offenses in that would be count 4 would be allied to count 1, and we would elect on count 1. And I will tender the plea sheets if you wish to have them.
All right. And one last question to the state. Is there any, if we go through with this today, this is what Mr. Ryan does in fact want to do, is there any sentencing agreement or recommendation made for the court's consideration?
No, Your Honor, there are no agreements. Each side is free to come in and ask for whatever sentence they believe is appropriate at the time of sentencing.
All right. Why don't you give me the plea sheets, and while you're doing that, Mr. Wobrowski, there's been a lot of information provided. What's your position?
All right, okay, with respect to those 3 cases, we are tendering new plea sheets, and to that end, we are withdrawing Mr. Ryan's firmly entered plea of not guilty and pleading of guilty to the indictments. As the prosecutor stated, there is no agreement as to sentencing on those cases, and we do, having gone over the plea sheets, I do agree with the state's merger analysis. I have no dispute as to that. I will note that we would also obviously also be requesting a PSI, setting the matter out for sentencing a little bit farther out than normal, as we had previously discussed with the court and the prosecutor, and the prosecutor had no objection to that, given Mr. Ryan's current physical condition and ongoing medical treatment. We would also note that there are 5 pending probation matters that would also have to be set on the date of sentencing.
Okay. Do you have a date in mind for sentencing?
We initially had discussed the end of June, but we were hoping to push it out even just a little bit farther.
What date do you have in mind?
I was looking at, I can do either the 14th or the 21st or even the 28th of July. Whichever.
I would do the 14th. I have no problem going to July 14th. Do you have a problem with July 14th?
That's fine, Your Honor. That's fine, and I'll discuss that date with the Marcy's Law individuals. If any one of them have a serious problem, I'll file a motion to reset that, but that's fine for me now.
It's in my briefcase on the floor, but so the 7/14, Michelle, you had mentioned doing it in at 1:30.
That's why I was putting it like one of those days, because I actually have nothing yet in the afternoon set.
Mr. Griffin, are you okay with 7/14 at 1:30?
That would make sense to me, Your Honor.
Okay. Now, there was one other question. I'm drawing a blank. Hopefully I'll remember in a moment. Mr. Wobrowski, based upon everything we discussed, then, are you asking the court to withdraw your client's pre-sentence plea? Not. Oh, I know what it was. I'm sorry. In addition to setting those probation cases on the day of sentencing, it's my understanding that, recognizing that there's going to be some prison term in this case, these combined cases, that you would be asking at the time of sentencing to terminate the old community control cases, so that he would just be going forward with any sentence. Thank you. And any sanctions and responsibility on these three cases.
That is correct, Your Honor.
Do you have a position on that issue?
I have no objection to that, provided that he pleads guilty on the three pending cases.
Got it. Okay. All right, let me just check that sentencing date real quick. All right, good. July 14th is a good day for this court as well. Okay. Mr. Ryan, you've been very patient listening to all this. Have you followed along what we've been discussing so far? Yes, Your Honor. Do you understand everything that we've been discussing? Yes, Your Honor. Is this what you want to do today? Yes, Your Honor. I'm going to ask you a series of questions to make sure you understand what's going on and to confirm that, in fact, this is what you want to do. But anytime I ask you a question that you don't understand, ask me to explain further, and at any time, if you want to take a break, consult with your attorney. Let me know that, and I'll stop these proceedings so that you can talk to Attorney Bobrowski, okay? Okay, Your Honor.
He hasn't texted me. I was going to, but I don't know if I should. It's during the school, can I?
All right. You can answer these. Excuse me. You can answer these questions yes or no. And again, if at any time you don't understand something, stop me. Are you a U.S. citizen? Yes, Your Honor. Do you read and write the English language? Yes, Your Honor. Do you understand that your attorney has asked me to withdraw your previously entered plea of not guilty and enter plea of guilty to these three separate indictments? Yes, Your Honor. Now, the first case, you are pleading to 9 charges, but you will only be sentenced and convicted of counts 1, 2, 5, 7, and 9. Count 1 and 2 are, count 1 is failure to trafficking, a felony of the 3rd degree. Count 2 is trafficking in drugs, a felony of the 3rd degree that has a $581 cash forfeiture and a class 2 driver's license suspension. Count 5 is trafficking in cocaine, a felony of the 4th degree with that same forfeiture suspension. Count 7 is trafficking in fentanyl, the same forfeiture conviction, which is a felony of the 5th degree. And count 9 is possession of criminal tools, a felony 5. Do you understand those charges? Yes, Your Honor. Now, the first 2 charges, the felony 3s, each carry 9, 12, 18, 24, 36 months in prison and up to $10,000 in fines. The 5th case, or the 5th charge, the trafficking F4, carries 6 to 18 months in prison in monthly increments up to $5,000 in fines. The last 2 charges, of which you'll be sentenced on counts 7 and 9, trafficking and possession, both felony 5s, they carry 6 to 12 months in prison and up to $2,500 in fines. Do you understand those possible penalties? Yes, Your Honor. Do you understand the nature of those charges and the factual basis for those charges? Yes, Your Honor. How do you plead to those charges in that case? Guilty, Your Honor. I'm going to skip the middle case now for a moment and go to the last case, the 25-11292 case. There's 4 charges you're pleading guilty to in this indictment, but you will only be sentenced and convicted on counts 1, 2, and 3. Count 1 and count 2 are possession of cocaine and fentanyl. They're those same felony 5, 6 to 12 months in prison and the $2,500 in fines. The failure to comply in this case is a misdemeanor of the 1st degree. It carries up to 6 months in jail and a $1,000 fine. Do you understand those possible penalties? Yes, Your Honor. In light of what this court could, and do you understand the nature of those charges and the factual basis of those charges? Yes, Your Honor. In light of what the court could sentence you there to this case, how do you plead to those charges? Guilty, Your Honor. All right. The last case, 24, that I'm going to go through, 24 CR 112365. This case has 9 charges in the indictment that you'll be pleading guilty to, but you'll only be convicted of counts 1, 2, 5, 7, and 9. Now, I'm going to go in reverse order because of the complexity of this. The count 9, driving under suspension, is a misdemeanor of the 1st degree. It carries that same up to 6 months in jail and a $1,000 fine. The OVI in this case is an unclassified misdemeanor. The unclassified misdemeanor in this case carries a minimum 30 days in jail and a maximum of 1 year in jail. There's a minimum $1,040 fine that must be imposed and a minimum 2-year driver's license suspension, which could potentially be reduced to 1 year. There's also a forfeiture for any vehicle involved and a registration requirement for plates and an alcohol detector if you are given driving privileges during the term of the suspension. Do you understand those? And one other thing. if you were to get a fourth DUI within 10 years of the conviction date, that DUI could be charged as a felony. Do you understand that?
Yes, Your Honor.
All right. Now, the next 3 counts that I'm going to go over are a little more complicated. Counts 1 and 2 are aggravated vehicular homicide, and count 5 is vehicular assault. I found the first 2 of those charges are felonies of the first degree. The last charge I just mentioned, count 5, the aggravated vehicular assault, is a felony of the second degree. These are a little more complex, and I'm going to go over them with you. And if at any time you want to stop me because you don't understand something or question me, please do, okay?
Yes, Your Honor.
These charges carry with them something called, these are qualifying offenses, meaning they carry an indefinite term of incarceration, or what some people call a tail. In other words, unlike all the other charges that have a set amount, there's an actual period of time that you will be sentenced in a range. Do you understand that?
Yes, Your Honor.
All right, I'm going to explain how that works on these 3 charges. Do you understand that you're pleading guilty to more than one offense that requires the court to impose indefinite sentences? That's counts 1, 2, and 5 in this indictment.
Yes, Your Honor.
Do you understand that you will receive both a minimum sentence and a maximum sentence or term for each of these 5 charges?
Yes, Your Honor.
Do you understand for the first 2 charges, which are felonies of the first degree, the court will select the minimum 2 from the range of 3 to 11 years in yearly increments on each of those charges. And on the 5th case, or 5th charge, aggravated vehicular assault, count 5, that's a felony of the second degree. The range that the court will select for the minimum is 2 to 8 years in yearly increments. Do you understand that?
Yes, Your Honor.
Do you understand that this court could decide if those sentences, or this court will decide if those sentences must be served concurrently or consecutively to each other?
Yes, Your Honor.
Understand the difference between concurrent sentences and consecutive sentences?
Yes, Your Honor.
Okay. Do you understand that that decision will affect the length of your minimum and maximum term?
Yes, Your Honor.
Do you understand the longest minimum term that you could serve on these 3 would be 11 plus 11 is 22, plus 8 is 29 years. Do you understand that?
Yes, Your Honor.
Now, the maximum you could receive is 29 years plus 6.5, which is the longest term of the most serious offense. So 29 plus 6.5 is 35.5 years. Do you understand that?
Yes, Your Honor.
Okay. Now, there's also non-qualifying. Actually, no, there's no non-qualifying offenses on this particular case. Okay. Now, Mr. Griffin, the aggravated vehicular assault charges in this case, counts 1 and 2, and I believe count 5, the aggravated vehicular homicides and the aggravated vehicular assault cases do carry mandatory time of incarceration.
That's correct, Your Honor. And if you could just double check, I think I put that on the plea sheets under the section, is it mandatory? I've
You did.
indicated yes.
Yes, it is.
Yeah.
As noted.
All right.
Thank you.
Now, because the sentences in those 3 charges, counts 1, 2, and 5, the 2 aggravated vehicular homicide charges and the aggravated vehicular assault charges are mandatory. What does that mean? Number 1, it means that you will have to serve whatever term of incarceration this court imposes. You'll have to serve it in full. You will not be eligible for early release mechanisms like judicial release or overcrowding or healthcare release. You will not receive good time credit or earned credits for good behavior during those sentences. You will actually have to serve those sentences in full. Do you understand that?
Yes, sir.
Okay. You will still get credit for your pretrial incarceration. In other words, the time you've been in jail will be credited against your overall sentence. But the prison time you receive on those 3 charges is mandatory and must be served in full. The other charges you receive, if there's any independent prison time in addition to those 3 charges, you would be eligible for good time credits or reduction in your sentence by good behavior through earned credits in the institution. Do you understand that?
Yes, sir.
Okay. Now, because of the nature of the indefinite sentences, there's a presumption that you will be released from prison on those charges after you've served them. And the way this works, I know this is complicated, but the way it works is if I sentence you to any of the other prison sentences that are definite, let's just take, for example, count 1, the failure to comply. If I gave you a year, That year would be served first. Then you would start to serve the indefinite sentences. So they're served at the end. Do you understand that?
Yes, sir.
Okay. I'm telling you that because once you've served any definite terms, and then you start serving the indefinite terms, whatever they are, there's a presumption that you're going to be released from prison on the earliest date. So make it simple. If I gave you 8 years, there's a presumption you'd be released at 8 years. But if you have bad behavior in the institution, or there's violations or problems that are caused, or other institutional abnormalities that occur, you can be held over and not be released from your presumptive early release date, which is your minimum term. Do you understand that?
Yes, sir.
That decision is not made by this court. It's made by the Ohio Department of Corrections. They will determine whether or not you are going to be released at your early minimum release date, or if you're going to serve a longer term. Do you understand that?
Yes, sir.
This court's not involved in that decision. It has no veto power to change that decision. That's solely in the discretion of the Ohio Department of Corrections. Do you understand that?
Yes, sir.
Okay. Now, if the department said you had to serve, let's say hypothetically, an extra year, there's a new presumption that you'd be released then. But again, if there's continued bad behavior, you'd be held over. And that process could repeat itself until you reach your maximum sentence. If you did reach your maximum sentence, you would have to be released from prison at that time. Do you understand that?
Yes, sir.
Okay. The aggravated vehicular homicide cases also carry a possible $20,000 in fines, and the aggravated vehicular assault case carries a possible $15,000 in fines. That's a lot. There's also a Class 1 driver's license suspension. The Class 1 driver's license suspension is a lifetime suspension. Do you understand that?
Yes, sir.
That's a lot to digest, a lot to go through, and a lot to think about. So I'm going to ask you at this point, do you have any questions about what we just went over for the middle indictment regarding the aggravated vehicular homicide and assault charges?
No, Your Honor, I don't.
Do you understand the nature of those charges, the factual basis for those charges?
Yeah.
How do you plead to those charges, Mr. Ryan?
Guilty, Your Honor.
Mr. Ryan, with regard to all of these matters we've discussed today, do you have any questions for me at this point?
No, Your Honor.
Okay. I'm going to continue on. And again, if you want to stop me, please do. Has anybody threatened you today in any way in order, or at any time, in order to get you to plead guilty to these charges?
No, Your Honor.
Has anybody promised you anything other than what you've heard discussed in court on the record?
No, Your Honor.
Okay. Vicky, he answered no?
Yes.
Yes.
Thank you, Vicky. You had a chance to go over 3 sets of plea sheets on each indictment. Is that correct?
Yes, Your Honor.
You reviewed these with your attorney and you went over your rights on them, correct?
Yes, Your Honor.
Do you understand the rights that Attorney Bobrovsky went over with you as he went through through the plea sheets?
Yes, Your Honor.
You signed each one on the back page, correct?
Yes, Your Honor.
Did you do that voluntarily?
Yes, Your Honor.
Are you satisfied with the legal services that Mr. Bobrovsky has provided?
Your Honor.
Do you understand that by pleading guilty today, you're making a complete admission of the facts alleged in all these indictments, and you did commit these offenses?
Yes, Your Honor.
Do you understand upon a plea of guilty, this court could enter a judgment of guilty against you and proceed directly to sentence?
Yes, Your Honor.
Do you understand that in addition to the fines that I've gone over with you, you could be required to pay other financial sanctions, such as court costs, restitution, supervision fees, and court-appointed attorneys' fees?
Yes, Your Honor.
Now, Mr. Ryan, this is another area that's a little complex. I'm going to talk to you about post-release control and what's going to happen when you're released from prison. Once you have completed all of your prison terms and you are released, you will be placed on supervision by the Ohio Department of Corrections for a minimum of 2 years and a maximum of 5 years. That means you'll be under supervision of the APA for 2 to 5 years. Do you understand that?
Yes, Your Honor.
Do you understand that if you are placed on post-release control and you violate the rules, the terms, or the conditions of post-release control, the Ohio Adult Parole Authority can return you to prison for up to 9 months for each of those violations, up to a maximum of 50% of the stated prison term for all violations. Do you understand that?
Yes, Your Honor.
Do you understand if you're convicted of a new felony while you're on post-release control, in addition to being punished for the new offense, the court can terminate post-release control and impose a prison term for that violation? And if that happened, and you got a prison term for the new felony conviction, do you understand those sentences would have to be served consecutively to each other?
Yes, Your Honor.
Let's talk about your constitutional rights. You have very important rights that you must waive or give up today in order for me to accept this plea. Do you understand that you have a right to have 12 jurors or me as a judge determine your case? And if you seek a jury trial, all 12 jurors must agree that the state of Ohio has proven you guilty beyond a reasonable doubt before you can be convicted.
Yes, Your Honor.
Do you understand Attorney Bobrowski can question, confront, and cross-examine witnesses who testify against you at trial, and you have the right to compel or force witnesses to come to court on your behalf by issuing subpoenas?
Yes, Your Honor.
Do you understand that the state must prove you're guilty on a reasonable doubt as to each element of these charges before you can be convicted, and you have a right to remain silent throughout any trial, and your silence cannot be commented upon or used against you in any way?
Yes, Your Honor.
Let's talk about appellate rights. You have limited appellate rights based upon a plea because there'll be no trial in this case. Do you understand that you do have a right to appeal a maximum sentence? But other than that, your appellate rights are limited. Do you understand any appeal you wish to file must be filed within 30 days of the date of your sentencing?
Yes, Your Honor.
Do you have any questions about appellate rights?
And I know that you can appeal if it's maximum. That's the only thing I know.
Okay? There are some very, very other limited situations in which you could raise an appeal, but they would have to be, they're scrutinized, and again, you will not have the full ability to appeal like you would if you went to trial and were convicted. Do you understand that?
Yes, Your Honor.
Okay. Now, we are going to order a pre-sentence investigative report. That report will give me background information about you, about what happened in these events. The victims and the family members will be able to participate and make comments and statements if they wish. I will be advised about any restitution requests, any kind of prior criminal history you have, and you'll be able to make a comment if you wish. You don't have to comment in the probation report. You can wait to open court if you choose. I won't hold it against you if you don't want to talk to probation. Pardon me, but they will give you that opportunity, and they'll come to the jail to interview you if you wish to cooperate. Do you understand that?
Yes, Your Honor.
Okay. Now, there has been no sentencing recommendation, no sentencing agreement, no sentencing discussions of any nature in this case, other than me going through the possible prison penalties, the possible fines, and possible forfeitures. Do you understand that?
Yes, Your Honor.
Sometimes the defense lawyer and the prosecutor will, and the victims' families will all agree on a sentence and ask the court to accept that sentence and say, Judge, we would ask you to impose X, whatever that might be. And the court can consider that. But even if there was a recommendation, even if there was an agreement, I'm not bound by it. At the end of the day, I will make the final decision regarding your sentence. I'll listen to what the prosecutor says, the victims' families, the police officers if they wish, your attorney, and you. At the end of the day, there's no sentencing promises, no sentencing agreements, and the decision will be mine. Do you understand that?
Sure.
Have any questions about that?
No.
Okay. Mr. Ryan, we've talked about a lot of things today. I'm going to ask you again. Do you understand everything that's gone on here today?
Yes, Your Honor.
Do you have any questions for me? Is there anything you're not sure of or anything you want to bring to my attention?
No, Your Honor.
Having considered all of your rights, the information on the plea sheets, the information you went over with Attorney Bobrowski, and the information you and I discussed together, is it still your desire to plead guilty today?
Yes, sir.
The record will reflect that Mr. Ryan is in open court with counsel, advised of all constitutional rights, and has made a knowing, intelligent, and voluntary waiver of those rights. The record will also reflect that I find that he understands the nature of these charges, the effect of the plea, and the maximum penalties that can be imposed. Finding his plea to be voluntary, this court accepts his plea of guilty on all three of these indictments, finds him guilty as charged, and by way of indictment in each of these cases. Prosecutor Griffin, relative to all these matters, is there anything I missed, anything you want to go over, or anything you think I need to address with Mr. Ryan at this time?
I don't believe so. Thank you, Your Honor.
Mr. Bobrowski, anything I missed from your perspective or anything you want to address?
No, Your Honor.
Mr. Ryan, do you have any questions for me at this point?
No, Your Honor.
Mr. Griffin, actually, let me ask Michelle, is there anybody on Zoom who is participating that has Marcy's Law rights that wishes to be heard at this time or have any questions for me, Michelle?
Not that they've messaged me.
Okay, well, I'm letting those folks on Zoom who are participating know.
I think actually,
If you have a question or a comment at this point, I will entertain or allow anybody from the victims' families or anybody who has Marcy's Law rights to either make a statement about or ask a question. But I would ask you that to withhold commentary relative to sentencing. We will give everyone an opportunity to be heard at the time of sentencing who wishes to. So I don't want to necessarily hear about sentencing thoughts at this point. But if there's questions that anybody has who's been participating, they can ask them. Michelle?
No, Your Honor.
Okay. We will go off the record. We'll get the PSI order. We will be back here for sentencing on June 14th. Thank you, everybody, today. I'm sorry, July 14th. July 14th. Ms. Ryan, see you back in a few months. I appreciate everybody's hard work on this case. Thank you so much. We're in recess.
Thank you.
Thank you, officer, for your patience.